In this lecture, let us discuss part 1 of the Constitution of India, Union and its territory. And we shall be discussing 4 articles, Articles 1 to 4. But first up, 2014, we had 28 states in India and we had 7 union territories. But in 2014, Andhra Pradesh was reorganized. Andhra Pradesh was bifurcated into Andhra Pradesh and Telangana. A new state, Telangana, was carved out from Andhra Pradesh. That means post 2014, we had 29 states and 7 union territories. Then on August 6, 2019, Jammu and Kashmir was also reorganized. The then state was downgraded because Jammu and Kashmir had a special status. The state of Jammu and Kashmir was downgraded to that of a union territory, and Jammu and Kashmir was reorganized and bifurcated into union territories. 2 union territories, Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. But this Jammu and Kashmir reorganization bill came into effect, entered into force on October 31, 2019. So the parliament decided, the government decided that we will enact, that we will enforce, that we will implement this Jammu and Kashmir Reorganization Act on 31st October 2019. But why? October 31 is the birth anniversary of Sardar Vallabhbhai Patel, the Iron Man of India. And we also call him the Man of Unity. Why? There were close to 562 princely states when British was governing India. And now majority of these princely states were to be merged with the Union of India. And there was one man responsible for that, Sardar Vallabhbhai Patel. He was pivotal, he was instrumental in merging majority of these 562 princely states with the Union of India. That is why we call him the Man of Unity as well. 31st October is the birth anniversary of Sardar Vallabhbhai Patel, the Man of Unity. So if Jammu and Kashmir was downgraded to that of Union territories and it was completely merged with the Union of India, the government decided, the government thought that let's coincide this with the birth anniversary of Sardar Vallabhbhai Patel. So this Jammu and Kashmir Reorganization Bill, which bifurcated Jammu and Kashmir into 2 union territories, it came into effect on 31st October 2019. That means on this date, we had 28 states again, but also 9 union territories. So 28 states and 9 union territories. But something else happened. 26th January 2020, what we celebrate as the Republic Day. On 26th January 2020, 2 union territories were merged. Daman and Diu was one union territory. Dadra and Nagar Haveli was another union territory. Effective 26th January 2020, both these union territories were merged together. And now we have this common union territory, which is named as Daman and Diu, Dadra and Nagar Haveli. So that means if we look at the territory of India right now, we have 28 states and we have 8 union territories. 2 additional union territories, Jammu and Kashmir and Ladakh. But 2 union territories were also merged, Dadra and Nagar Haveli and Daman and Diu. So right now, we have 28 states and 8 union territories. Now let's discuss part 1 of the Constitution of India, Union and its territory, and we shall be discussing 4 articles, Articles 1 to Article 4. But first up, Article 1, the name and territory of the Union. If you look at Article 1, Clause 1, it says, India, that is Bharat, shall be a union of states. There are 2 phrases very important for you to understand. India, that is Bharat, and Union of States. First, let's look at what is this India, that is Bharat, which basically means that we have dual name for this country. The name of this country is India as well as Bharat. That is what we call India, that is Bharat. But why both these names? When Constituent Assembly was set up, and what is this Constituent Assembly? A body which is tasked to draft the Constitution of India. That means once India was given independence, now this independent country needs to have its own constitution because we cannot be run on the basis of the laws passed by the British Parliament. Now we are independent. So then in 1946, the British government decided that let's give power to the people of India. Let them frame their own constitution. And that is how cabinet mission was set up. That is how in 1946, power was given to the people of this country that you can frame your own constitution. And on 9th of December 1946, this Constituent Assembly met for the first time. This Constituent Assembly had to decide what are going to be the rules on the basis of which this country will be run. But the question also was, what should be the name of this country? Some people said that we should stick to this name India. Why? Because we are known world over by this name. We are known throughout the world as India, so let's stick to this name India. But others said, no, India is the name given by the colonial empire. India is an alien name. India is a foreign name. We should stick to our traditional name, which is Bharat. Some people said, no, why call it India? Why call it Bharat? Let's call it Bharatvarsh. Some people said, no, we should call it Hindustan. Some people said, no, we should call it Jammu Dvip, the land of the Jambu tree, because that is how we were known in the ancient India. Some people said, who were very close, very sympathetic to Soviet Union, because they believed in the socialist ideology, the communist ideology. They said, let's imitate USSR, Union of Soviet Socialist Republics. So we should call this country as Union of Sovereign States of India. So there was a confusion. There was a lot of debate. There was a lot of discussion and deliberation on the nomenclature for this country, the name of this country. Some said, let's stick to India. Some said, no, we need a traditional name, Bharat. Some said, no, let's call it Hindustan. Some said, no, let's call it the Union of Sovereign Socialist States of India on the lines of USSR. And ultimately, this confusion, this problem, this controversy was settled. Two names were given, reflecting the modernity as well as the tradition. So that is why the name of this country, we have dual name. India, that is Bharat. So both these are the names for this country. India, that is Bharat. So this controversy was settled when Constitution was given to us, when the Constitution was enacted on 26 January 1950. But even then, some people were not satisfied. In 2016, an activist from Maharashtra, he approached the Supreme Court and said, "Dear Supreme Court, I am filing a public interest litigation." What is this PIL? We will discuss in detail when we will talk about judiciary. But this individual from Maharashtra, he filed a public interest litigation in the Supreme Court and asked the Supreme Court, "Dear Supreme Court, please issue a directive to the Parliament. Please ask Parliament to change the name of this country. We should stick to the name Bharat, not India, because India represents the colonial aspirations. We should stick to the traditional name, which is Bharat." Ultimately, the Supreme Court rejected this public interest litigation. The then Chief Justice of India said, "Don't come to us with these frivolous emotional issues. Use the power of public interest litigation to fight corruption in the society, to fight the climate change in this country." So we are rejecting this public interest litigation. That means once and for all, the dust is settled, the matter is resolved. We have dual name for this country, India, that is Bharat. But some people were still not satisfied. May 2020, an individual named Nama, he approached the Supreme Court and filed another public interest litigation. That, "Dear Supreme Court, what you have to do, issue an order. Issue an order to the Parliament that please have a constitutional amendment. Let's amend the constitution and delete this word India, because India does not represent the tradition of this country. So we should call this country Bharat and not India." But in June 2020, the Supreme Court decided to postpone the hearing on this public interest litigation. So now we are almost certain again. We have dual name for this country, India, that is Bharat, reflecting the glorious mix of modernity as well as the tradition. So when we look at union and its territory, part 1 of the Constitution of India, I told you we have to discuss articles 1 to 4. But before that, how many states do we have? 28. How many union territories do we have? 8. But why do we have union territories in the first place? That I'm going to discuss when we will talk about the chapter Union Territories. So right now we are only going to talk about union and its territory. So basically, The territory of India consists of what? We can either have states, or we can have union territories, or we can have something else that I'm going to tell you slightly later. But we are not going to discuss the rationale behind why we have union territories. That we will discuss slightly later. But right now, what are we talking about? We are talking about Article 1. Article 1, Clause 1. India, that is Bharat, shall be a union of states. Two phrases are important. Number one, India, that is Bharat, which means that we have dual name for this country, India as well as Bharat. Second is, shall be a union of states. This is where there is a controversy. What is the controversy? When we say union of states, does that mean India is a unitary constitution? If India is a federal constitution, Article 1 should have mentioned India, that is Bharat, shall be a federation of states. Because if you are saying India, that is Bharat, shall be a union of states, that means the Constitution of India is itself accepting that we are a unitary constitution. This question was posed to Dr. B.R. Ambedkar, the architect of our constitution, the chairman of the drafting committee of the Constitution of India. He was asked, if our constitution is federal in character, federal in nature, then why are you using the phrase union of states? Instead, you should have said India, that is Bharat, shall be a federation of states. But you're saying India, that is Bharat, shall be a union of states. Should we assume that Indian constitution is unitary in character? Dr. B.R. Ambedkar replied, and he said, no, Indian constitution is federal in character. But I have used the phrase union of states for two reasons. What are these two reasons? Number one, India is not the result of an agreement between states. He was asked to explain, what do you mean when you say India is not the result of an agreement between states? He said India was already there. So India as a political entity was not created because the states got together and created India. India was already there. Yes, there were these princely states, and they decided to give up their sovereignty and merge with the Union of India, accede to the Union of India. That is why India as a political entity was already there. So we can't say that India is the result of an agreement between states. And this agreement created India. India was already there. That is why we call it a union of states. We don't call it a federation of states. But he was asked to explain more. He said, look at United States of America. If you look at United States of America, which is in Northern America, there were 13 British colonies. Primarily, these 13 areas were under the control of the British Empire, the British colonial empire. Then the people of these 13 colonies, they decided to revolt. They decided to launch a war for independence. That is what we call America's War for Independence. And ultimately, the British rule was overthrown. And these 13 British colonies, they became sovereign, they became independent. But then what happened? All these 13 British colonies who gained independence, who gained sovereignty, they decided to come together. They wanted, let's now create a United States of America. That means United States of America was not present before. This United States of America was created when these 13 British colonies, they liberated themselves. They came out of colonialism, and ultimately they decided to come together and create United States of America. That is why United States of America, we call it a federation of states, because this United States of America has been created because of an agreement between these 13 British colonies. But that's not the case with India. India as a political entity was already there. Now these princely states were given an option. Either you can join India or you can join Pakistan. And thanks to Sardar Vallabhbhai Patel, majority of these princely states, they decided to be part of India. They decided to accede. They decided to merge with the Union of India. That is why we can't call it a federation of states, because India is not the result of an agreement between the states. That's one reason. Second reason why B.R. Ambedkar said, I have not used the term federation of states, but instead I have used the term union of states, because no state has the right to secede from the Union of India. Till about 1970s, there was a perception that when we call a constitution as federal constitution, when we call a political entity as a federation, one part of this federation may at any point in time come out of this federation. That means, let's say, for example, there is one political entity which has been created because of the agreement between various constituent units, because of the agreement of various states. One state may come out of this agreement and declare independence, declare sovereignty, take its sovereignty back. That means one state can secede from the federation. But this is something that we cannot give to any Indian state. When we say we are calling India, that is Bharat, shall be a union of states, that means no unit of this union, no state has the power, has the authority, has the option of coming out of the Union of India. That means there is no provision for secession. That is why B.R. Ambedkar said, I have used the phrase union of states. That means when we look at Article 1, Clause 1, India, that is Bharat, shall be a union of states. India, that is Bharat, that means dual name for this country. India as well as Bharat shall be a union of states. But does that mean Indian constitution is unitary in character? Because Article 1 of the Constitution of India says India, that is Bharat, shall be a union of states. But B.R. Ambedkar said, no, we are a federal constitution. But I'm using the phrase union of states because of two reasons. Number one, India is not the result of an agreement between states. And number two, no state has the right, has the option, has the power to come out of the Union of India, to secede from the Union of India. That is what we call India, that is Bharat, shall be a union of states. That is Article 1, Clause 1. Let's look at Article 1, Clause 2. The states and territories thereof shall be specified in the first schedule. Now, for this, what we need to understand. Number one, what is a schedule? Number two, what is the reason to have a schedule? But first up, when we look at Article 1, Clause 2, it says the states and territories thereof shall be specified in first schedule. So what is the schedule? In this schedule, what will be mentioned? The names of the 28 states that we have, the 8 union territories that we have. That means if we look at the first schedule of the Constitution of India, it talks about, it details the names of the states that we have, the names of the territories that we have. That is why we have first schedule. But the point is, what is a schedule and what is the need to have a schedule in the Constitution of India? Originally, in 1950, when Constitution was enacted, we had 8 schedules of the Constitution. Over a period of time, 4 more schedules were added to the Constitution of India. So right now, we have 12 schedules of Indian Constitution. But what is a schedule? Schedule is basically an explanatory memorandum of an article. What does that mean? A schedule is an explanatory memorandum of an article. That means if there is an article in the Constitution of India which requires more explanation, for that what we do? We add a schedule at the end of the Constitution. But what is the purpose? Purpose is basically cosmetic. And what do we mean by a cosmetic requirement for having a schedule in the Constitution? Let's say, for example, instead of this phrase, the states and territories thereof shall be specified in the first schedule. Instead of this, we could also have mentioned the states and territories thereof are specified below. So below this article, we would have a list of 28 states and 8 union territories. But constitution makers thought if there is an article which requires more explanation, for that we should add a schedule at the end of the Constitution. Otherwise, this article would become very bulky. So if without a schedule, if there was no schedule, Article 1, Clause 2 would have been like this. The names of the states and territories are mentioned below. 28 states, 8 union territories. The entire article would be very bulky. So maybe constitution makers at that point in time realized that lean is in. So if we want to make our constitution, the articles in the constitution as short as possible, as precise as possible, if an article requires more explanation, don't add it to the text of the Constitution. Instead, add a schedule at the end of the Constitution. I'll give you one more example. And this is something that we will discuss in detail later on. But for you to understand what is a schedule, what is the need to have a schedule, let me give you one example. One example is Article 246 of the Constitution of India. What is Article 246? it talks about distribution of powers. That means some powers are given to the center, the parliament, some powers are given to the states, some powers are given jointly to both center as well as state. That is why we call a union list, a state list, a concurrent list. That means on banking, on insurance, on currency, on foreign affairs, on defense, who has the power? Who has the lone power to make laws? Parliament. So all these items are mentioned under the union list. But states also have some powers: law and order, land, police, agriculture, gambling. These powers are given to the states. But there are some powers which are given to both center as well as states, state legislatures as well as the parliament. For example, criminal procedure code, civil procedure code, marriage, divorce. When we look at Article 246, if all these subjects would have been mentioned under Article 246, then this Article 246 would be very bulky. So, to prevent the situation, to ensure lean is in, what happened? A schedule was added at the end of the Constitution. And this distribution of powers is mentioned under 7th schedule of the Constitution of India. Long story short, Article 1, Clause 2, the names of the states and territories thereof shall be specified in first schedule. So what is first schedule? First schedule details the names of 28 states and 8 union territories that we have. But what is a schedule? Schedule is basically an explanatory memorandum of an article. If an article requires more explanation, don't add it to the text of the Constitution. Add a schedule at the end of the Constitution. Why? Cosmetic reason. So that this article would not be bulky. So that if an article requires more explanation, add this explanation at the end of the Constitution by adding a schedule. That is what we call a schedule. And what is first schedule? It mentions the names of 28 states and 8 union territories that we have. And then Article 1, Clause 3. The territory of India shall comprise of, number 1. That means when we look at Article 1, Part 1 of the Constitution of India, talks about 4 articles. 1, 2, 3, 4. What is Part 1? Union and its territory. That means if the union is India, what is the territory that is part of India? That is under the control of India. That is part of India. For that, there has to be some explanation. And that explanation is provided by Article 1. And Article 1, Clause 3 talks about what types of territories can we have. So Article 1, Clause 3 tells us that either we can have states, or we can have union territories, or we can have acquired territories. That means, let's say, for example, if this Clause C was not present, that means the territory of India would have been fixed forever. We could neither gift a part of our territory to another country, nor we could have acquired a part of a territory of another country. That means the territory of India would have been fixed forever. To prevent that situation from happening, the constitution makers thought that let's have another category in place. The territory of India will consist of either we can have states, the 28 states that we have, or we can have union territories, the 8 union territories that we have, or we can have acquired territories. And how can I give you an example of an acquired territory? One such example is the French settlement of Pondicherry, or now we call it Puducherry. Pondicherry basically was a French colony. But then in 1954, there was an agreement between the government of India and the government of France. And it was because of that agreement that Pondicherry became part of India. But it was not originally part of India. It was acquired. India acquired the territory of Pondicherry from France. That is why we call it an acquired territory. And then in 1962-63, Pondicherry became the Union Territory of India. Because till 1962, Pondicherry was administered by the government of India as an acquired territory. Why? There is a difference between signing an agreement and ratifying an agreement. What is the difference? Let's say, for example, in 1954, there was an agreement signed between the two governments, Government of India and the Government of France. What was the agreement? Both governments agreed that this territory, Pondicherry, should be acquired by India. This territory should be legally acquired by India from France. There was government to government agreement. But this agreement, which was signed between the government of India and the government of France, it had to be ratified by the French Parliament. French Parliament took some time, and French Parliament ratified this agreement in the year 1962. That means this agreement was signed in 1954. But it was only the signing of an agreement, because only the governments of both the countries, they accepted this agreement. But this agreement needs to be ratified. And how can we ratify it? We can ratify it by parliamentary approval. This parliamentary approval was given by the French Parliament in the year 1962, and that is how Pondicherry legally became the part of India. But from 1954, when the agreement was signed, till 1962, when the ratification was done by the French Parliament, in these years altogether, French settlement of Pondicherry was administered by the government of India as an acquired territory. That means either we can have states, or we can have union territories, or we can have acquired territories. Tomorrow, we can acquire a part of another country and make it part of India. But ultimately, there is a difference between signing an agreement and ratifying an agreement. Agreement is signed by governments, but agreements are ratified by the respective legislatures, respective parliaments. And it was only in 1962, when the French Parliament ratified the treaty, ratified the agreement, that Pondicherry became a legal part of India, and it was given the status of a union territory. This completes our Article 1 of the Constitution of India. So recap, Article 1, Clause 1, India, that is Bharat, shall be a union of states. We have dual name for this country, India as well as Bharat. Union of states does not mean that Indian constitution is unitary. It means Indian constitution is federal, but for two reasons, we have used the term or the phrase union of states instead of federation of states. The names of the states and territories shall be mentioned where? It shall be specified in the first schedule. What is a schedule? If an article requires more explanation, add a schedule at the end of the Constitution. So schedule is basically an explanatory memorandum of an article, and it is only for cosmetic measures. Then, if you look at the territory of India, either we can have states, or we can have union territories, or we can have acquired territories. And one such example of an acquired territory is the French settlement of Pondicherry.